Today, I would like to talk to you about copyright law. So, what qualifies for copyright protection? Well, first, a copyright is a property right in an original work of authorship that is fixed in a tangible medium of expression. Copyrights protect the expression of the idea and will not protect the idea itself. So, copyrights protect literature, motion pictures, books, sound recordings, architectural works, even coding, uh, and other various expressions. The thing with copyrights is that there's no functional aspect to the work itself. So, what does copyrights protect? Well, they give the owner of a copyright exclusive right to reproduce it, prepare derivative works, distribute copies, perform or display the works publicly. And this is exclusive rights, meaning you can exclude others from using it, and you can license a party to do any of those things as well. And just going back, derivative works, are works that are based on an original work. So typically, a movie that's based on a book would be considered a derivative work of that book. The term of a copyright is typically the author's life plus 70 years, unless there's some other relationship going on. Most typically, it's in an employment relationship, and that creates a work for hire scenario. And the term of a copyright in that situation is going to be 95 years. Again, this is like a scope of employment analysis. So if you're a startup and you're hiring people to produce content, you definitely want to make sure that you're having the proper agreements in place so that you make sure your term for your copyright is what you want. So how do you get a copyright? Well, copyrights are vested immediately in the author at the time that you create it. So whenever you fix that idea into an actual physical or tangible expression, and it could be electronic, it doesn't have to be something you actually carry, but there is electronic, you get immediate rights. However, if you don't register your copyright with United States Patent and Trademark Office, the USPTO Copyright Office, you won't be able to file suit against anybody and enforce your copyrights. So there are benefits of registering your copyrights. The first one, as I mentioned, is you will be able to enforce your copyright and actually be able to file suit. You can't file suit unless you have a copyright registered from the USPTO. Other benefits of registering include if you do file suit and you win, you are entitled to attorney's costs and fees from the opposing side, and you could potentially get statutory damages. Statutory damages are easier to prove because you don't have to prove actual damages. But you don't have that benefit unless you have a registered copyright before infringement takes place. So if infringement takes place by somebody and you want to sue them, you need to file for a copyright first, but you won't be able to get statutory damages for the infringement that occurred before you've registered your copyright, only after you register your copyright. And then for work for hires, just a side note is that the author in a work for hire situation basically gives up their rights for their employer. And they're going to extinguish any claim later on. Again, you want to have the proper agreements in place for a work for hire situation.